Thank you. Thank you very much. Hello, everybody. Thank you for joining us on Zoom as well as thank you for joining us on live on YouTube. We have an interesting conversation going on today, and we have some amazing panel members too for this discussion. So I would first want to hand it over to Madhura. Madhura, you want to get started?
Yes, sure. Thank you, Smita. My name is Madhura. I represent Indian Lawyers Association, a non-profit network of lawyers across India. And we are here to kind of create this network where all the lawyers and legal professionals of the country are involved. And we kind of create it as a movement with a very big vision of addressing the issues in our legal system, like dependency of cases or the vacancies of judges at different levels or the lack of digitalization, things like that. So we actually work on a model of having different chapters across India, and we currently have reached about 70 chapters. So these chapters kind of do a lot of things, events, for example, educational events, cultural events, they celebrate festivals, just come together and a network basically. So and they add a lot of local flavor to their operations. So this is our a model at a very high level, and through this event especially, I would like to invite all of you to our first in-person event after the pandemic, which is happening in Mumbai on 10th of December. This event will host about 500 plus lawyers from Mumbai and across India, and have 6 panels on very important legal issues. We are having different judges coming down, general counsels of different MNCs, senior counsels, lawyers. So all these details will be in your mailbox by tomorrow. Also, they are available on our website and social media. So we look forward to seeing all of you there. And Smita, over to you. Thank you for doing these panels for us.
Thank you. Thank you so much. And as I discussed the topic, which is inquiries and evidence gathering and role of technology. Of course, after pandemic, during pandemic and after pandemic, we have realized the role of technology, even in inquiries, but technology was always there. We have used it throughout. So we're going to touch base on it and understand how we can understand this better or use it effectively. So a little bit about my company. I run this company called KelpHR. We have been pioneers in the industry of prevention of sexual harassment at workplaces. We started in 2013, the same year we got the law. 750 clients, we have touched lives, and lakhs of employees, and tens and thousands of IC members whom we conduct conversations, learning programs for. So that is about us. Now, of course, about the eminent guest today, the panel members here. I have Sebastian Sir here. Sebastian Sir is the Country Director, India, for International Center for Missing and Exploited Children, USA. He's former law enforcement officer from CBI and an Air Force veteran. He's a certified fraud examiner, computer hacking, a forensic investigator, and a master trainer for Interpol on technology crime investigations. He has a BE in electronics, telecommunications engineering, and MS in cyber law and cyber security. He was a director with Forensic and Dispute Services and the head for security and business continuity for Deloitte South Asia. He's among the top 100 cybersecurity experts in CyberQuest. So when we were discussing with Sebastian Sir, we asked him the question that, did you do all this in your current life? Or you had to really, this is an enormous achievement and really amazing, sir. And I think you're the best fit for the panel of today's discussion here. Thank you very much for coming in. Okay. Then I move to another young lawyer here, Jenna V. Krishnan. She is an advocate with 13 years of experience in the areas of commercial and employment law, cross-border contracts, commercial litigation and arbitrations, negotiations and strategies for dispute resolution and or dispute avoidance, among others. She began her career in commercial litigation and arbitration in Bombay High Court and other civil courts in Mumbai. She carried the practical lessons learned at these venerated courts into her role as a legal counsel in India. at a boutique global management consulting company. During her 9 years at the company, Jenna ascended to being their group general counsel, issues and dispute resolutions. Her years as a litigator, a litigant, and a legal counsel offered valuable insight into the gaps in India's or indeed the global legal system. Thus, in early 2022, Jenna launched the Daily Lawyer, a platform to provide practical and precise legal information through a corporate training law courses, podcast, the Daily Lawyer podcast, and one-on-one consultation. Jenna, I must tell you that at KelpHR, when we started, the idea was the same, to simplify the law. And I see that through the Daily Lawyer podcast, that's exactly what you do, because the lay person really don't understand a lot of technicalities in the law. So thank you very much for doing
Thank you. Thank you, Smita. Thank you very much. And yes, we definitely have a synergy on that.
So launching what we are here for. As I mentioned earlier, that of course, pandemic taught us the role of technology. And prior to pandemic, also, we were using technology quite a bit in our day-to-day IC proceedings, right from receiving a complaint, right? If you look at the law says that the complaint can be given in writing in 6 copies to the presiding officer. Of course, we are in the technology era. Nobody writes 6 copies or takes photocopies of 6 copies. We use email. So right from there, the technology has a kind of replaced some things in the law. Acknowledging an email is also important. The complaint email, earlier it used to be face-to-face. A complainant would simply hand over a complaint letter to the presiding officer. But now, because of technology, because of work from anywhere policies, that is something that is a question mark, and a complainant would send an email and wait for a response. Many a time she's wondering if it has gone to a black hole. So as a presiding officer, how vigilant are you? How responsive are you? And how you're ensuring that the person understands that you are looking at her email and not just ignoring it. So this is a very important aspect here. Third important thing is serving summons or notice of hearings to all the parties who are involved. Before our meeting today, I was telling the panel members that in one of our cases where the complainant actually was a visitor and we did not have a formal email ID for her, and she was not based out of any closed vicinity, so we could not meet her personally. So many of her summons were served on WhatsApp, and we actually took a screenshot of blue ticks of WhatsApp and kept it as a record for us. So this is where the technology has evolved and helped us online proceedings. The next important part is online inquiries. Earlier, it used to be face-to-face, but considering the vicinity and where all we are placed, and sometimes the presiding officer is shared across locations, the external member is shared across locations. So online inquiries using Zoom, using Teams has become the norm. So how do we have etiquettes to manage? That is also important. Cross-examination also can be done online, and we definitely do it online. Evidences, which is the hero of our conversation today. What are those aspects that evidences, how technology has impacted evidences is something that we'll be looking at. And of course, giving final copies to each and every parties online is also become the norm. Earlier, we used to print out so many copies and give one set to each of the parties. It was getting cumbersome. Now we PDF it, sign it online, and give it to the parties. So, role of technology in evidence gathering. We all must know that in PoSH Act, Evidence Act is not really applicable. The law works on not proving harassment beyond reasonable doubt, but looks at balance of probability. We definitely look at proving it beyond reasonable doubt, but there are times when it does not occur, because any sexual harassment would happen inside a cubicle or in a car or in the lift where there is no evidences or no direct witnesses available. In these scenarios, we look at balance of probability. And there is a very famous case of Medha Kotwal versus Lele versus UOI, which speaks about principles of natural justice, which speaks about circumstantial evidences, and also balance of probability. So just quickly touching upon, I try to do a laundry list of all the technology that we use for inquiry. Of course, this is not an exhaustive list. I'm sure I'm missing on many aspects, but I thought let's just put it up there. So WhatsApp, very important, there is a confusion when somebody's submitting WhatsApp as an evidence. They submit it as a screenshot. I always go back to them and say, why don't you download it? Because then it comes in a chronology order. You know the numbers are correct and it's not fudged. There was a time when screenshot was fudged when it was sent to us. And I have Sebastian sir who will speak about forensic evidences and how to identify that and where to reach out for. Snapchat, SMSs, call logs, mobile or landline. Issue with call logs is if it is a prepaid number, there are times when we do not get those mobile logs. That is a challenge. So we should be aware as an IC member of these challenges. And the person can get it from their own biller, and they generally, if they have a postpaid billing, they get it, right? But if you have to get it from the phone company, then there is an FIR which is required. So it becomes a little cumbersome. Emails, of course, if it is official, you have an access, you can request your IT department to get it. But if it's a personal email, you have to request the parties to give it to you. Office Messenger exchange like Teams or Microsoft Exchange, again, it is available to you. CCTV footages, if it has happened within your premises, it is available to you. If it is outside your premises, then you'll have to request to the parties. Truecallers is also used quite extensively, and video conferencing. If any videos, the exchange has happened on video, this is something that could also act as a evidences. Now, I'm going to take a pause here because while we understand what is the role of the technology, we have just started discussing what is the role of technology and looked at the laundry list. I would want to invite Sebastian sir to take us to understand what is the forensic evidence is all about. It is very technical for a lay person. So Sebastian sir, with all your experience, grace us and tell us what should we be aware of.
Yeah, let me share my screen. Thank you. Is my screen visible to you all?
Yes, sir.
Okay. So I'm going to present about 5 to 8 minutes very briefly about digital forensics in a layman's language without introducing any technical jargons, etc. So I'll be covering a brief definition. What are the challenges for handling digital evidence, and what are some of the guidelines available from the CPO, etc. Then what is the digital forensic methodology and practice that are followed, and some of the challenges that you encounter in case you do not have a forensic specialist in your team and you are using some local IT, etc. What are the pitfalls that are likely to come up, and how forensic team members add value not only in any IC investigation but also in any investigations, and also is a concept called forensic readiness. I think people are dragging onto the screen, which is creating a line on the screen. Request all of you not to drag on the screen, please. Now, digital evidence is one of the very simple layman's definition is information of probative value that is stored or transmitted in a digital format. This is the definition given by SWEDGE, Scientific Working Group on Digital Evidence, as early as early 2002 or 2001. And even the digitally signed by defined by them as technology that generate, process, or store information in binary format. Going to the next slide. What are some of the challenges in handling digital evidence? I just wanted to put it in 2-3 buckets on this. Electronic evidence is very delicate. So you can very easily damage an evidence through shocks, vibrations, sunlight, direct exposure to sunlight or high temperature, high frequency waves like X-rays, electromagnetic and electrostatic fields, etc. So as I'm not going into much details, if anyone would have any doubt on this, maybe we can clear it on the question answer session. Then it also creates a lot of opportunities and threats, like digital evidence anyway is a secondary evidence. No one can see it by your naked eyes. You need special tools that interpret and tell you what are the contents of that particular media. It can be easily altered without trace. When I say easily altered without trace, it depends upon what is configured to be captured, that a user's activity, etc. What are the logs that are enabled, etc. That's what I was telling about the importance of having a forensic team member in the team, so that no one even unintentionally gets into or maybe moves or alters any evidence. Then what is to be remembered by this internal committee is that, like, whatever you do, maybe after that first level, the case may go into a second level of court proceedings, and the onus is on the prosecution team to prove the integrity of evidence that is collected and presented before them, and in establishing provenance and chain of custody. Very briefly, ACPO stands for Association of Civil Police Officers, and this is an organization based out of UK, and they were the first ones in early 90s to come out with guidelines for handling digital evidence. And the ACPO guidelines are part of SOPs in most of the standard operating procedures followed by any country. The first one says that no action taken should change the data which may be subsequently relied upon court. So when you're going to going to access an email, access a mobile phone, or access any SMS, etc., one of the most important thing about is that your action should not cause any change in that particular content. So that is one thing. And second one says that in case it is necessary to access original data, the person who is accessing must be competent to do so. The competency tells about his qualification, his experience, and his authorization to do so. Especially when you're getting into maybe collecting information from a server, etc. If you directly connect it without forensic tool, it will leave a log trail, which could subsequently be coming to the rescue of the offender, saying that this is technically not correct evidence. Going to the next point, that is, whatever actions you do in a digital investigation, an audit trail has to be created. So if you are using what you call accepted tools, the audit trail is automatically created by the tool itself. Whereas there are some situations where the internal committee members use IT team and they are not aware of these requirements, and the tool that they use do not create an audit trail, which will subsequently come in a court of law for questions like, okay, what all you have done? So there is no trail in the tool. So that will create problem. And lastly, the supervisory responsibilities, which tell whoever is in charge of the investigation has an overall responsibility to ensure that rule number 1, 2, 3 are followed and adhered to. And this is the SOP for handling any digital evidence. Going to the digital forensic methodology and practice, it is a combination of reliable and tested tool sets, systematic and scientifically proven procedures, and typically comprising of 4 phases, which is called acquisition, preservation, analysis, and presentation. So in the acquisition phase, what actually you're doing is what to look for and where is it likely. Let me give an example, like if your car or two-wheeler has become faulty, and maybe when you take it to a good expert repair or mechanic, from the sound itself, he'll come to know where is the issue. It is something similar here. If you have a forensic guy, you tell the situation, he will know where is that evidence likely and how to gather it. So that is the acquisition point, or you can say the initiating point of chain of custody. Then comes preservation. Now, unlike conventional crimes, say for example, there is a murder and somebody is lying on the road, and maybe on the fingernails of the say victim, there is some scratch, etc., or maybe some blood stains that are come up from the offender. So there is always a possibility that a piece of that particular material can be taken out and send it for the examination in a forensic lab. But when it comes to digital evidence, you cannot cut a piece in a small piece of maybe a hard disk or a floppy disk or a pen drive and send it to forensic examination. So here you need to have a forensically acceptable copy. And then that is the second stage of any forensic analysis. You are preserving the original evidence in such a manner that original is not touched at all. In the sense, when you say you are not getting into any of, you're protecting the original evidence and at the same time creating a forensically sound copies of that original evidence so that analysis can be done on the copies and not on the originals. And original is always available for court reviews, and that's what the procedure called preservation. And third one, analysis. It is a structured and detailed examination. It aims to tell what happened and who or what is accountable for it. It's basically an analysis that maintains an audit trail as required by law, and at the same time collects information and evidence in such a manner, and then subsequently it is interpreted in such a manner it is available to court of law. And the last part is, again, it's for judicial review. The acceptance of the findings depends on tools and procedures and processes used, qualifications and experience of the expert, and manner and language of presentation. So when I say manner and language of the presentation, you cannot put a lot of technical jargons into it. And is the jury able to understand it? That's what I meant. So now, this slide, I purposely put it for telling you something, generally, any investigating agency, even law enforcement people, even today, they have a tendency, the moment they get something, okay, let me go through it, and open a mobile phone or a computer hard disk, etc., searching for evidence. Now, I just wanted to give you, this was one of the typical, I prepared this slide almost about 15 years ago when I was working in, I think more than 15 years ago, Chara Khotala related case. So just wanted to tell you, my aim is to show you, say, assuming that you have a hard disk available with you, which is having a capacity of 500 GB. And this 500 GB hard disk, if you assume that it is all full of Word documents, what would be the number of pages that can be created out of it? And if it is stacked one upon other on the top of it, what will be the height of that printout, basically? So normally, a A4 sheet, if you type it, you will be able to create 52 lines, and in each line you have 80 characters, that is inclusive of space. That comes to be something like 4 kilobyte. So for every 4 kilobyte, you will have 1 page of data. I'm just trying to, and the height of or a thickness here, because I'm going to stack one upon the other, I just want to see height or thickness of this A4 sheet is 0.04 inch. So when I say height or thickness, it is this particular thing I am telling about, this particular thickness, that is 0.004 inch. So we can safely assume the height of 4 kilobyte data is 0.004 inch. Now, I just want to multiply it 1250 times and make it 5 MB, because ultimately my aim is to reach 500 GB. What will be the height of this data? So when it is 5 MB, the height of printout on A4 sheet will be 5 inches. And I am just going to make it again, multiplying it to say 5 GB. Then the height will be 5,000 inches. We have still not reached 500 GB. So going to the 500 GB, what will be the height? It will be 5 lakh inches. So you can imagine 5 lakh inches. I am just comparing it with the height of Qutub Minar, the largest minaret in India, which is only 2,867 inches. So what I actually wanted to say was that even a simple mobile phone device, which normally these days has something like 120 GB or 60 GB, etc., or 50 GB, whatever that, it is not possible for you to search the whole thing and find out the evidence. And even if you found the evidence, it will already create a trail in the log saying that this phone was accessed while it was in your presence, because chain of custody, all these things will be indicating that the phone was taken, or you may be having access to this phone at that time. And all the suspect or maybe the accused will have enough, will be able to say that all these were collected by me and loaded into it subsequently, etc. So my aim of putting this slide is to see that whatever is there with you, never open any storage media containing likely evidences without forensic tools. Now, in the beginning itself, I told that there is a requirement of forensic specialists, how they can add value. There are two things in this. Like in any investigation, there is a stage called planning and preparation. what will be the crime scene. Like in internal inquiries, most of the things that could come, what is the type of mobile phone or computer, what is the operating system, is an Apple, iPhone, Android or anything, or if it's a computer, it's a Windows or Mac or any other thing. What is the environment, if it is compute, if it is standing alone as a network computer, or it is a remote type of thing. What are the type of encryptions if you do not know how to deal with it? What are the different applications in that? What are different tools required to maybe forensically collect that data from that tool? What are the volume sizes? So in case you need a forensic image, how much of empty disk you need to carry? Are the collections going to be discrete or remote? Suppose in case, even if it's an employee from the same company, do we need to collect certain evidence remotely without his knowledge? So he'll be able to help with that. And if it is a crime scene, if you're in actually in a scene, then understanding the environment and managing crime scene, they are going to be of help. How to do scene searches, where to look for, what to look for, what is the system architecture like, where are the likely evidences. Volatile data is a thing that tells about some of the data that could be lost in case you shut down the device. So before shutting down the device, how to collect such type of data. In an on-scene interview, what are the things to be asked, especially on technology areas, how to conduct search and seizure, etc. So these are all some of the areas where a forensic person is going to value add to an internal committee. Now, coming to my last slide, forensic readiness. Every organization must understand, we install CCTV for capturing something that has passed in the maybe previous day or maybe previous week, month, etc. So same way, the organization should be having a forensic readiness approach to ensure that any investigation that are likely to come up tomorrow, your systems are already appropriately configured to ensure that the evidences are available. Now, it's the way, like some murder has happened yesterday, and today if you install a CCTV, it's not going to catch up previous day stuff. So your computer systems should be configured in such a manner that, okay, what are the logs to be captured? What are the different application related events have to be captured? And then this will also help the organizations demonstrate to regulators, yes, they have done everything. But if they have not done so, the law enforcement agency, etc., subsequently who might be required to hand over this case, etc., they might find fault with the organizations. So if you have, if you understand, if you need to know about a forensic readiness concept, you need to connect with some of the forensic teams and understand what is the way in which the entire IT systems have to be configured for investigations in future. And anything further on this, maybe we can have interactions. And I am handing over my screen back. Thank you.
Thank you, Sebastian, sir. And sir, I remember one particular event, and I think this person was forensic person, and I must share this case now that it is over. It was some time back. So a lady had complained saying that there is this guy I know, he's clicking my pictures continuously. I had confronted him. I told him that, I think you're clicking my pictures, whenever I'm not looking, but I have a feeling you're doing that. He showed me his phone. There was nothing on his phone. So I was like, I didn't know what to do, but I want to, I didn't complain at that point of time, but I still feel he's continuing to do that. And she made this complaint to IC. IC got the complaint. We called the person. He said that I've explained to her earlier also, I've not been clicking her pictures. You can see my phone. At that time, we approached, I don't know if they were called forensics or IT persons, because it was beyond our capacity, layman's capacity, to understand that what is happening. If she's feeling that she's being clicked, is she just in some la-la land, or really this is happening? And this person came in, looked at his machine, and he figured out that by default, whenever he's clicking this picture, it is getting saved on his cloud data, and a copy of it is getting wiped off from his phone. It was quite a discovery for us, and we realized there were 1,000+ pictures of this woman who he has been clicking, and that was quite a case for us to handle.
Yeah. Even if he's not uploading to the cloud, it may be available in the deleted part of the his mobile storage, and which can be always recovered by him very easily using some forensic tool or even some data recovery tool. So in a plain look, it will appear that nothing is there in the machine.
Yeah. So when I hear you so loud and clear that you can't have forensic person after the case has happened. You should be ready, forensic ready all the time. And as an organization, and we are really going to talk about it in our next IC meetings with all our clients across. Thank you, Sebastian sir, for that. Now, I would really want to invite Jenna. Jenna, I have few questions for you. What do you think about technology's role? And if you want to start something, I have a series of questions, but if you want to say something to begin with.
Thank you. First of all, I want to say thank you to you, Smita, Niharika, and of course, Madhura with ILA for giving us this opportunity to tell everybody what we know, but also all of us the opportunity to learn from each other. What do I have to say about technology? Of course, Sebastian sir has spoken about the technical side. I will only say that technology is extremely useful for even as an IC, for us in a fact-finding exercise, for us to engage in a fact-finding exercise, just like you have demonstrated. You said you gave 2 examples in the last 15 minutes about how you yourself have used technology in coming to the root of the matter, which if we did not have this, then we would not have known. That poor girl would continue to have felt like, oh my God, is she like hallucinating, or is she being needlessly anxious? So I think you answered the question by giving these 2 wonderful examples. But then I would love to tell you in specific, I mean, based on the questions that you have.
So Jenna, first and foremost question from a legal perspective, can IC demand personal records of people? Can they say, give me your phone, I want to see your chat history? Because people can say, oh, it's my personal, it is nothing related to work, so why should we do? So can this demand be done?
So the answer to this question will be dependent on whose personal records we are going to be requesting. So let us say that the complainant has come to us, and you gave this example. You initially said that somebody gave you a screenshot, and you always say that give me a download of this. I don't want the screenshot, I want the download. One of the reasons that you gave that I want a download is because so that I'm very sure that the screenshot has not been fudged. The other reason for getting the download is also because I need to see context. What has happened before. I'll give you an example. I had a case. One girl and a girl and a boy. Okay, they were working in different organizations, but then the organizations were like vendors. So one organization is the buyer, and the other organization is a vendor to this organization. So there was some picture that this complainant gave us, which had it was a picture of some skimpy clothes or something like that. Okay, so the suggestion to us was that the respondent was asking her to, I don't know, buy these clothes or something like that. So when we asked her for the entire screen, the entire conversation, we realized that the tone of the conversation was completely different. Right? When you see only the screenshot based on whatever little she says, the screenshot will validate her story. But when you see the entire conversation, you realize that there was actually a relationship, and therefore you cannot see the screenshot in isolation. Right? So in these kind of situations, let us say that we asked the complainant that you please give us the entire download of the conversation. And she says, no, but that is a violation of my privacy. Now we have to remember that as IC, we are supposed to decide. Now, we can only decide if we have information. If you don't provide us information, then we are well within our rights to have what we call as adverse inference. We will say that, okay, fine, we are not satisfied with the information that you gave. You may claim that it is a violation of your privacy, but the fact of the matter is that you've not given us enough to go on so that we can sort of either rely on you or rely on the other side. So to answer your question, can we ask for personal information? By all means we can, because we have to understand that we still have powers of a civil court when the inquiry is on, not before and not after. So we can definitely summon for information, but can they have these kind of now when it comes to witnesses, that's a totally different aspect when it comes to witnesses, right? When it comes to complainants and respondents, you can say that, you can have adverse inferences drawn out against each of them. But when it comes to witnesses, in my view and in my experience, even as an IC member, I have not pushed a witness. If the witness tells me that, no, I am not comfortable, this is my personal information, I will not push a witness. Neither can I draw any adverse inference against a witness. At most, I will probably say that the witness's testimony is not completely in line with either one, but that's the most I can do. So I hope I answered your question.
I think that is so important because, I think sometimes we become hyperactive and we might demand it to witness also and reprimand them for not giving. I think that's a very important input, and also calling it out if they're saying it is privacy. I get very hassled when somebody says, oh, it's my private matter. I as an IC person might not ask, but we could draw inferences, which is, I think, a very important point, Jenna, that you have brought about. So now, just leading to that, should we then say that, okay, we want this period to this period? Should we draw some boundaries over it, that we don't want the entire scale, or we want from this period to this period? And what is the intersection of privacy of the person and powers of IC? And when should IC seek external help? So this is like 2-3 questions which are related
into one. Okay, so I'll try and answer you serially. There is absolutely nothing wrong in having a boundary. In fact, Sebastian sir can come in with his expertise, but I was telling you people offline the other day that we have had experiences where we had engaged, in fact, Deloitte itself for one of our matters. And at that time, we had told them, we are not interested in getting a full download of your entire conversation and in your life. It is irrelevant to us. So from that angle, you can definitely tell me that, listen, you can't tell me from 2014 to now, give me everything. That will certainly be an invasion of my privacy. And I agree with that. If the complaint is from March of 2022, this thing started happening and it's been serially happening since so long, then I can say, okay, give me from March of 2022. Because before March, my mandate has started from then, right? The mandate that is given to me, the complaint that is given to me, unless in the course of the investigation, I find out that there is something even before that, then we can ask for a download before that. But otherwise, to start with, there is absolutely nothing wrong in bounding. And like you rightly said that, yes, this will also help us in counteracting the privacy argument of whichever side is raising it. And again, I'll give you a similar example. When we engaged Deloitte as a forensic expert in a particular matter, we had said we want to go through your entire Gmail records, which they said, listen, that is an absolute invasion of privacy, because my Gmail records, and we wanted, there was a PAN card copy that has been sent, and we wanted to make sure that, so we said, but it has been sent to your Gmail address and we know, but we have to make sure that it has gone. So that was the privacy angle came there, where I will not give you access to my entire Gmail record. You tell me specifically what are the dates. You pick out the dates and tell me those dates ka emails we will extract and give. So what I'm trying to essentially say is that, yes, there is a place for a privacy argument, and there is a place where the privacy argument may not apply, in the sense that it will lead to adverse inference. Okay, so that is answering your second question. And your third question, when do we need a forensic expert? I do not believe that we need a forensic expert in every case when it comes to PoSH, because not every, some cases, I don't mean to dilute the importance. I am sure that every case is important. What I'm trying to say is that there are some cases which need an extra input, a more expert input based on the circumstances of the case. So we will need, like, for example, you gave that, this person, she couldn't see anything on the phone, but then she kept feeling that there was something, right? So that is an example of when we will need an expert. We will need expert input. In the case that I am saying, why I went to Deloitte is because we also could not find anything on the device that said that. And this was before, when I saw Sir's presentation, I realized we ourselves have made blunders while opening the device and all of that. And we were called out on that blunder, but we could not find anything on the device. And which is why we said, okay, there must be something, and it's our responsibility to dig deeper, which is why we went to a forensic expert. So the short answer to your third question is that when the circumstances of the case, you feel that, yes, I need expert advice. Without that, it's not within my competency or the competency of anybody else within the IC, then by all means get an expert.
Yeah, I just want to add 1 or 2 points onto this. One is regarding the timelines. Definitely timeline is very, very important. Otherwise, you will be ending up with a flood of material to be manually reviewed. One. Number two, privacy angle. In order to reduce privacy related things, you can always develop keywords purely related to the case. Okay, there was an incident, or there was say we went to say Taj Coromandel Hotel. So Taj Coromandel can be a keyword for the investigations. So same way, maybe about 10 to 15 important keywords that are unique to the investigation that you give to a forensic expert. He can collect anything related to that from that keywords and put it up to you. And then the third thing is like everyone inside the IC, including the person who is going to analyze and the lawyer who is part of it, etc. They are going to, if they sign a confidentiality agreement, that is going to give a lot of comfort to the victim and maybe also the accused, etc., saying that my data is not going to go outside this particular thing. And at the end of this thing, everything is going to be destroyed. So these are all the way you can counter all these challenges to this. That's all from my side.
A great input, and there's a follow-up question that is coming to my mind, and this keeps coming in all the SH queries, that for how many years should we save these technology evidences or any form of evidences? Is there a year? I think Jenna
to the best of my knowledge, there is no particular threshold that has been given under the law that you have to keep for 3 years, 5 years. But what we advise is that we just maintain the 7, like how all our tax documents, we say 7 years, all important documents, we say 7 years. So we just advise that you just maintain that and keep it for 7 years. I invite sir's expertise on this, but we also say that once the matter is over, because we are all bound by confidentiality obligations under the law, we say that you all that evidence that you've collected, which however you've stored it in a folder, that we ask them to lock it, like have a digital lock, the access to which will be available only to the PO and one high ranking, like what we call under PoSH as the employer. And we say that if nobody else, including the IC members, once it is done, should have access to that vault.
Yeah, I agree with Jenna. It is generally 7 years, and I think this particular guideline is from the tax laws. Otherwise, there is no other guideline that say how many years it has to be maintained. So either one, if it is closed, then maybe you can close it immediately. If it is not closed, till the time it is not closed, or if it is closed and if you want to still maintain it, maybe up to 7 years, that's what as a best practice it is done. Otherwise, there is no, I couldn't get any ruling related to this anywhere else. And general practice these days for what you call saving is something like as what you told, that is putting it in a DigiLocker. We put it actually a folder which is encrypted, and the password of that is available to maybe 2 or 3 people who are only supposed to handle it. And that particular digital folder will have logs enabled to see who all have opened it and when they have opened it, what documents were accessed, etc., so that any abuse, misuse, etc., can be tracked.
Brilliant. So that is getting me to another very a question which is on people's minds all the time. We have started interviewing people online, right? And we have video recordings, okay, of complainant, respondent, witnesses, right? And then we get it scribed for XYZ reasons. So there has been a lot of pushback from everybody, like there are 3 hours of recording and scribing, that is such an ordeal. So can in court of law, instead of the scribed document which is signed up, can the recording be produced instead of a document? Is a question that I keep getting. Jenna, could you add anything?
Yeah, I can. To answer your question, can a recording be produced in a court of law? The answer is definitely yes, a recording can be produced. There is a procedure to produce the recording, that you have to have a certificate under the Evidence Act called Certificate 65B and so on. And that there is a technical requirement how the certificate is managed and so on. So yeah, the short answer to that will be yes. However, the requirement of transcribing is not, it's not a pedantic requirement. It is not a formality. It's very, very useful, and I'm very happy that you brought this up. Now, it is supposed to be a statement of what I am telling you. Now, I am talking to you, Smita, and I'm just conversing with you, I'm chatting with you. And when we are in a PoSH inquiry, the emotions, both sides come. They are either very defensive, or they're very aggressive, or they're very sad. So there is a lot of emotion that happens. So you're saying a lot of things. Sometimes you're blabbering, you're just saying a lot of things. And it is very important that you stand by what you say. Okay, so in your statement, you get it transcribed. The reason why we have a written statement is because what is written does not move. It cannot change. And that is why it is a requirement that it has to be written. If I'm not talking about a legal, I'm not saying requirement from a legal aspect, point of view only. I am saying from the point of view of getting, for the IC to do their inquiry, for all the parties involved to get justice, for setting a precedent, for all of that, it is very important that we have written statements which will not change, which we can go back to 100 times if we want to make sure, listen, this is what has been spoken. And that is not always easy in a recording.
That's such an important aspect, that maybe not legally, but the context to it, I didn't mean what I said, and I mean this, that comes quite a bit. And then in a written document, it is in the simple.
And once a statement, when you're standing by your statement, you can also have in brackets, you can write that, added, or because this is a statement that is going to stand, this is a statement that you're going to stand by. So it's very, very important that the transcribing and the signing of that statement, reading and signing, happens.
Great, thank you for that input. So the next question that I have for you, Jenna, is about disappearing messages. Now that's quite a googly, because whenever there is a case and suddenly people say, okay, especially in Snapchat and nowadays in WhatsApp also, people enable disappearing message and then there is no trail left. So how do we ensure that this really helps us, and then, or we are not left in lurch? The IC is wondering what to do because there is no context, there's no background.
So thanks to Sir's presentation, my instinctive answer to this is that if there is a disappearing message, then we should get a forensic investigator involved right away, because they definitely will know more than us, and they'll guide us how to sort of get the evidence. So that will be my first answer. My second answer is that sometimes at least the complainant may have screenshots, and in this case we cannot ask for a download. So in this case we don't have a choice but to possibly rely on what is given to us in front of us, and then figure out from the surrounding circumstances, like collect circumstantial evidence to see whether it supports the complainant's stand or not. How do we ensure? That was your question, right? What else do we do as IC to ensure that? These are the only three things that we can do. Yeah, we can either, we can ensure that the disappearing messages was turned on before the date of the complaint or the incident complained of. Like supposing the disappearing messages was turned on later, then there is a clear adverse inference that you can draw against such and such person, and then obviously a forensic examiner will be able to figure it out. Now I invite Sir's comment on whether forensically we can recover even disappearing messages.
Yeah, you can, because see, if certain data is displayed on your screen, that means it is saved onto your media, whether you have given a name or without name, etc. There are different areas these get stored, etc. And the thing is that after how many days you are going to approach a forensic guy, or a thing is that, like, depending upon the capacity of this particular storage media, it will start overwriting after certain once the area is full. It is not that it has got unlimited capacity. There is just a capacity. Maybe the user has used it to almost 90%. That means only 10% of the area is left for this. Then as soon as such type of deleted or you say the message got deleted, then it can recover till the time it is not overwritten. So that is one thing. But logs related to this deleted message will remain, so that we will come to know that at so and so time, this particular message was deleted. That will remain there for quite long time. What was the content of the message will not be there, but then this particular message with sort of title will be available. And when was this configured to, as Sajana was telling, when was this configured to automatically delete? All these can be taken for inference, or maybe as a secondary evidence, or sorry, as a corroborating evidence to indicate that even if the original message is not there, yes, there was some message, it was deleted. If it was deleted, there was with certain bad or ill intention. This all can be inferred by the jury.
Okay, that is pretty interesting. Actually, I remember a case where a complainant had come and said that, the senior member in her organization would harass her, and there were WhatsApp favors that he had requested. Unfortunately, because she changed her handset, all the WhatsApp is no more existing. And we tried to contact WhatsApp, and WhatsApp said, we cannot help you actually. She had actually, we said, you'll have to get us the evidence and try your best to get the evidence. So she had actually found a hacker. Okay, and she came back to us and said that I found a hacker to get. So we were very worried about the entire approach, and we were not sure what to tell her, what to not tell her. Of course, she was trying to prove her point, that saying that somehow I'll get the access, but we were not sure if that was the right means to even venture. So fortunately for us, we could prove the case because we had other witnesses and evidences, and that got proven. But all these things are also coming up, and I think these, the parallel means are coming up, which is a little scary. And for us as IC, I think when such things come up, we suddenly realize, are we venturing into those dark world? So that's one experience I wanted to share. So coming to another instance, and I would want to pick your brains on that. There are many times sexual harassment happens in closed rooms, as I mentioned, and a victim wouldn't have any witness or any evidence to produce. There are times they come back with an audio recording which they wouldn't have asked for consent, or even video recording. Okay, they would take the video and shoot the entire behavior or audio, and they want to produce that. What is your take on that? Is it admissible? What do you think about it?
So when we are talking about consent for video and audio recording and all of that, we are talking about the Evidence Act. Those are the provisions of the Evidence Act. We have already discussed now and earlier that the strict principles of Evidence Act do not apply to the IC proceedings or other PoSH inquiries. So when the reason, it is obviously, it will not happen. Nobody is going to give consent if you're being sexually harassed. That harasser is not going to give you consent. Okay, can I do audio recording or video recording? So as an IC, in my personal opinion, we cannot be saying, I'm not going to accept this evidence because there is no consent. However, the question is how much I'm going to rely upon that evidence. And that's a totally different matter. We will pick up evidence what is given. That doesn't mean we're going to rely upon that evidence. We're going to listen to it. Then we're going to put it forth because we have to also send it to disclose to the other side that all of these evidence in this sort of video or audio recording was taken. And supposing the video and audio recording is extremely on its face, it tells you very clearly that there is a very clear sort of incidence of harassment, then of course you'll tell the other side what were you doing and all of that. But then I don't see any reason why you should not as IC rely upon that, because I think then it defeats the purpose of the IC. If we are
all right, that's such an important aspect, because there are times we say, oh, you have to take consent, and of course, why would somebody misbehave when they know they are being recorded? And that's important aspect.
When we can talk about consent being mandatory when, for instance, when we are doing a video, let's say on Zoom, we are interviewing a witness, we are interviewing an expert, we are interviewing the parties. At that time, yes, we will say we are taking consent. We will take consent and say this is going to be interviewed, or what this is going to be recorded. However, when I'm trying to record for the purposes of having evidence so that I can show you, listen, I was right and this guy is really a meanie, I don't think that, I mean, again, I'm saying that relying upon the evidence is different and taking evidence is different.
Got it. Thank you so much for that. And I'm going to share another aspect, and I would really want to pick your brains on that. In one of our cases, a photograph was shared, okay, as a important evidence, right? And both of them had their own perspective. Both of them had shared the same photograph. Okay, from the complainant's perspective, in the photograph, the respondent is standing very close to her, and which is making her uncomfortable. And same picture, the respondent had shared, saying that, look at she's saying she's a victim, but she's giving such amazing smile and she's smiling in the picture. So how is she a victim? So have you all come across something like this? And I mean, what would your take be on that same picture, evidence from both the parties, but different perspectives?
Then no, you have to see the circumstances. What else? Maybe ask the colleagues. I mean, ask each of them to, if the lady saying, I'm feeling uncomfortable, but that's the only thing she's saying. I don't like it, I'm feeling uncomfortable. He's standing very close, I don't like it. So what did you do? Have you ever said something? Because you can also tell her that your body language and does not show from the picture that you're feeling uncomfortable. So did you do anything? Did you speak to somebody? Maybe at that time he's a senior or whatever. So you didn't want to tell that person. Did you confide in a friend? Did you confide in your family? Did you confide in friends outside? Did you write it in your diary, like, dear diary, I'm so so then you start doing a fact-finding exercise by pulling out from others.
All right. Thank you, Sebastian, sir. Do you have any input? I know it's not your subject, it's a softer aspect from the perspective side, but if you have any input, please share.
Yeah, I think I agree with what Jenna has told. I specifically do not have anything on that particular photograph related thing, but then from a common sense perspective, if someone had a difficulty, he or she should not have been smiling and posing for that photograph. That's what I feel. And maybe then, as she said, if there was some concern she had, probably she could have raised it immediately with some of his close confidence or someone. I agree with that.
Yeah, we have some questions. I see Dr. Sandhya asking. One last question from my side. Is there any tips for a person who's stuck in malicious complaint? For instance, a part of screenshot is shared from the chat. Okay, so any input from you for a person in such a situation?
Yeah, I think. Sorry, Jenna, please go ahead.
No, sir, please go on.
Okay. Yeah. See, one screenshot, etc., may not give you a clearer picture. And maybe that screenshot can also tell when was the picture taken, where was that picture taken. Like if it is a GPS enabled camera or a mobile phone on which that particular picture was taken, you will get the date, you will get the device details, you will get the location. So what I just want to say was that a small forensic analysis tell that what was the so this can give you a bit connect the dots, something, and also a detailed forensic examination of anything if that person is able to submit. That all can be added up like this and maybe prove his innocence if you think that no, I am just held up on ransom and I am innocent, etc. So maybe he should provide and give more inputs to the IC relating to that can establish his innocence. And forensic tools can definitely give that. And what is to be done is subsequently collect the statements of the complainant and see whether these pictures are working out on that with any angle or not. I think that will help.
Sure. Thank you. I think we have come to the set of questions that we have thought for. And in conclusion, if there is anything both Jenna and Sebastian, sir, you would want to share to the IC committee from the perspective of evidence gathering, some final takeaway, and then I'll go back to the questions. I see a couple of questions there.
Yeah. One is that forensic readiness for any organization, for any investigation, not only IC investigations, any investigation that is likely to come up in future, their IT system should be forensic ready. Otherwise, what logs they have enabled, what they have logs they are not enabled, and they should get these details from a forensic guy, like, and check whether my IT systems are investigation friendly or not. If not, all things are going to be failing without getting any related evidence. And number two is always keep a association with one or two forensic examiners, so that in case of requirement, they can be onboarded quickly. Because I have seen many companies, they need a vendor related procedures before onboarding, because in these forensic related things, every day the device overwriting, many things happen. So the earlier, the better. So if they have a forensic guy, either as a part of their team or on call, or also on something like a organization is dedicated for this, etc., that will be helpful. And over to Jenna.
Thank you, sir. Yes, I agree. My first point was also that for IC, don't be afraid to ask for help. You don't need to do everything yourself, because at the end of the day, not all of us are experts. We are all doing this in order to get to a solution. That leads me to the second tip, which is we should have a solution-oriented mindset. Sometimes when we get a complaint, and especially because it is people from the own organization, we tend to make judgments in our brain only. We say, oh yeah, he's like this only. This is not the first time. I've also felt like that, because it happens. It's very human. So we should keep our personal sort of our personalities and our office designations outside the IC door. And when we are inside as an IC committee member, we are only acting in that capacity. And the third one is not to be afraid to dig deeper. We have, whichever way, there are plenty of ways possible. We can take expert help to figure out what is okay, what is not okay. You can even call a friend who's a lawyer or whatever, make sure that they are covered within the confidentiality obligations, but don't be afraid to dig deeper. So those are my 3 tips.
Amazing. And I think they are really great tips, both Sebastian sir and Jenna. But I have huge, I think around 4 questions on this. So I'm going to just quickly read them. I'll start from the bottom. So Nandita says, is it better to record or write down statements of complainant or respondent? Should IC write down, or should it be the parties themselves?
See, whosoever is the investigating agency, they should write down. And recording, if you're doing it, you should tell the parties and record, so that they are not caught by surprise. And it's also made it very clear to them, I am recording it just because if I miss some important points, I need to go back and review it. And generally the statements are written down by the investigating or the internal committees, whoever is the person who is taking care of it, and read the person who is going to sign statement, in case somebody is signing. In some cases the statements are not signed. So if the person who is wanting to sign, etc., he should be given it to that person, read it, satisfied, and then sign it. Otherwise also just read it out to him and say, even if they are not signing, this is what I have written. You have anything different from this, what you have told. So that actually creates a lot of confidence on the party who is being investigated. And for you also, like, okay, I have written down the statement, now I have made it and read out to him, he's agreeing with it. Even that part is also recorded as a CCTV or whatever it may be, etc. So that gives further transparency to the recording that is taking place. And
Yes.
We should not leave it to the person concerned or respondent or a complainant to write down the statements, etc. It has to be the work of the IC, no one else, or the investigator in any case.
Yeah, same. We suggest that the IC deputes one person who's a scribe among the IC. And we suggest also that every meeting with either the respondent, complainant, witness, whoever, is both recorded and transcribed exactly the way sir described. And we suggest that every statement must be signed, read, of course, and signed.
So Nandita, that's our expert giving you inputs. I prefer recording because I feel those people are so emotional at that point of time. And generally, these IC members are very, very senior people. Of course, you can have a scribe, but that's such a rare skill. I'm struggling to find good scribes in IC. So we prefer recording it and then we transcribe it. Of course, we do it. And there are organizations I know who make the complainant after the interview, they'll open up another room and tell her, now whatever you've told us, write it down. I feel it's a little inhuman because I feel she's already, she's already emotional. She shared everything to you, and now you're making her do amazing homework, which is draining. And we are not experts in scribing, so we take a recording and we scribe it immediately and send it to them. And as Jenna and Sebastian sir mentioned, we ensure that they read it, they understand this better, and sign it off. Yeah. Dr. Sandhya, I'm sorry, it's going too fast up. I can't see her question. Okay. Yeah. How important is it to transcribe? A lot of times ICs write a summary. Okay, they don't write the verbatim, but just the summary, which really may not capture the nuances.
Very important to transcribe. I do not recommend writing a summary at all, because we have to write a summary when we are writing the report. And at no other time are we supposed to write a summary. It's not our thoughts. We are just going to be acting as scribes for whatever we have heard, and based on that, we will be taking our decision. So I completely agree with you, Dr. Sandhya, that writing a summary definitely does not give the nuances, and also I don't think it is right at all for writing a summary. Our job, while we are conducting the inquiry, our job is to be a fact-finding machine, and then in the end, after the inquiry is over, we have 10 days to break our head and figure out what is it what is the decision we come to.
All right, thank you, Jenna, for that. There's another question. There's a judgment on this point. I don't know which point. Evidence recorded.
I think it is Parliament attack case where.
No, I'll tell you what this is. This is about, whether evidence taken in breach of privacy can be used.
Okay.
So there is a judgment on that, which says that though the method of getting that, evidence is tainted, but the evidence itself is not tainted. And if it is relevant, it can definitely be taken.
Yeah, and this is
Parliament attack case.
And this is in the court of law. So then we have a lower threshold in IC. So, right. But I think, Dr. Sandhya, were you referring to this when the question was, can the audio and video recordings be?
Yes.
Okay.
I'm saying for that particular point only.
All right, thank you. I think Tasneem is asking, report can be summary or detail of all inquiry. Question mark.
See, the report, I'll tell you, as an investigation in general, it has to be an executive summary, then the background and the investigation, what was the scope of investigation, period of investigation, what were the findings from interactions with people, what were the findings from review of documents, what was the findings from forensic, etc., if some technical team was used, etc., and then summarize, and then whether the allegation number wise, like there was 4 allegation number, proven or not proven, if proven, how, then proven, not proven, or partly proven, if it is partly proven, how, not proven, all these things have to be, and then just close it over there. It is up to the next team to decide whether a punishment should be given, etc. So generally what I am seeing in some of the reports are that they recommend punishments also there. It is not the job of an investigation team to recommend punishment. It is purely a fact-finding agency who, based on the inputs available to them, review the conduct the investigations and review the material that has come out during these investigations and prove or disprove the allegations 1, 2, 3. That's all.
Sir, I'm just going to go one step ahead because under the PoSH Act, the IC is supposed to provide recommendations as well. So yes, we are a fact-finding exercise, but then we have to also provide recommendations. But for everything else, in terms of what Sir said, was absolutely, I mean, I don't think we can get better than him. He has had years of experience doing this.
Yeah. So I have not done any PoSH investigation, but I was telling in a general investigation terms actually.
We get
Can I just intervene? Both of you are right. I'll tell you how. Sebastian, you're right. As far as investigation for an organization which are governed by service rules, there the IC will only say whether the person a complaint is upheld or not, whether the person is guilty or not. But those organizations which are not governed by service rules, there you need to recommend this is the punishment that is there. So both of you are right in that sense.
Thank you. Thank you. Anyway, I am not very familiar with in general. Thank you so much for that.
Very nice of you to unmute and then tell us this. So thanks.
You're welcome.
All right. So I think we have come to the end of the conversation. What we hear from all of you, and Nandita, you have another question. Did you raise your hand?
Yeah, thanks. I just wanted to clarify why I asked on the recording and transcribing issue, because what happens generally is that when we record, sometimes parties use it against, the councils will use it in an appeal stage, that the recordings were not given, and it's another big hassle. So what I wanted to ask is that if when you call either of the parties and one IC member starts transcribing, putting it exactly how the complainant is telling the story, you put it in their own words, but you put it on the computer, take a printout, let her read it and sign it, you save time and you save a challenge tomorrow in the courts, because they will ask for recordings. You know, you give us the recording, see how we were saying it there, how tomorrow you have gone back with the recording and written it in another way. Doesn't it create more complexity? That's my question.
So
No,
can I
are we
answer?
supposed to be? Yeah. In IC things, are we supposed to give a copy of recordings to them?
They might ask for it, the councils. I mean, so the parties might ask for it, natural justice.
No, normally not given in any investigation, but then Jana, please update. I do not know.
No, I want to clarify with Nandita. When you say councils will ask, are you talking about appeal stage in the court? Because there are no councils in an IC proceeding.
See, generally in practically what's happening, they're all being briefed by their lawyers behind stage. So they will come to the IC and start asking, give me my recording, or they will say what I said in my recording, I have not written exactly this statement which you have asked me now, which, you know, see, typically IC members will record, then after 2 days they will send it to them that we have transcribed it like this, now you sign it. That's when they will start creating problems that, no, I did not say this, that, you show me the recording. So I thought, as a best practice, on the same day, if the IC member just types it down exactly what the party is stating, take a printout, let her sign it. Tomorrow she can challenge it with, you know, show me the recording, I did not say that. Won't we waste more time, is what I'm asking.
So Nandita, that's why we suggest that one person be a scribe. See, none of us, like Smita rightly said, none of us have the capacity to write or type at the speed of somebody speaking. So we suggest that you definitely have a recording, but you do you transcribe it. One of them, you keep transcribing it, go back to the recording to make sure that you've taken everything, but everything happens on the same day. You don't allow the complainant to go till he or she has sat, a complainant, respondent, whoever, till he or she has sat, read, signed and finished. We are not doing this 2 days, 3 days, 1 week nonsense. I mean,
but this is practically, you know, happening where the IC members are giving it, and 2-3 days later they're going back home, listening to the recording.
I know that's a problem. Ideally, we are all talking about best case scenarios, best practices. We should not be doing that. Ideally, we all should be there together. You know, that is why we say that one person is only deputed as a scribe who's not using their brain and listening, and, you know, like answering, asking questions, you know, trying to figure out. We'll give that. So when, as a PO, I was a presiding officer, so that's what we used to do. We used to actually, each of us had roles to play.
Even I have one more technical solution. You have these days a lot of speech translation software which can be straight away translating live, and then only thing is that you need to edit it at the end of the session, which may not take more than 30 minutes or so. Edit it whatever is required so that it summarizes what he was talking, and then read it out to them. And if they have any doubt, it can be closed. I suggest Jana's, I agree with Jana's statement that as far as possible, it should be closed on the same day. So if the investigation time is, say, from 9 to, say, 5 p.m., you should do it from 9 to 3:30 or 4 p.m. so that you have time for all other things.
Yeah, I agree that we should do it fast. And I agree with Nandita when she's saying it gets a little cumbersome. Speech translation works well, but while Dr. Sandhya is saying doesn't work well all the time. But it's something that we are evolving over a period of time. As ICs, we also trying to find out the best practices, and what works for one set of organization may just not work for another set of organization. So as an organization, as an IC, I think you should be looking at the stuff that works for you, the technology that works for you, the processes that works for you, and evolve over a period of time. I think Bomaya Sam has raised their hand.
Yeah, hi. My name is Bonia.
Bonia.
I have a question. No worries, no worries. I have a question here. Is now there are a lot of companies who are virtually now working. That physical setup, still many of them have not come back yet. And for such organizations, having a physical signature, getting the documents physically signed is a technical issue because employees are spread across pan India or from other countries across. So is it okay in those scenarios to take acknowledgements on emails? Will that be okay?
Jenna, that's for you.
We suggest that you take digital signatures. That is possible. Digital signatures have been around for a while now. So we do not suggest email acknowledgements. I have never done an email acknowledgement so far, honestly. I'm okay to do email acknowledgement as part of, yes, okay, I got it, whatever. But I want a digital signature. And it's not that difficult to get a digital signature. So I would not recommend that. I also want to specifically answer Dr. Sandhya's point when she said that the speech-to-text software, they don't work very well. You're absolutely right, which is why we say that one of them again has to be a scribe. So when I was saying like we are actually transcribing, actually we are not doing that. We use something called Dragon. There's on Dragon software, speech-to-text.
Dragon naturally speaking.
Yeah,
it's almost
naturally
90% accuracy.
Yeah,
it's about
so
90% accuracy.
Yeah, so the scribe sits in front of his or her computer and just keeps staring, and then you can use your mouse and then quickly change the word. So that's what we do. No, by digital, I think Tasneem. Can I read the comment, Smita, if you don't mind?
Yeah, I will read.
No,
it.
digital signatures are not pasting your signature.
No.
Digital signatures are an encrypted thing by which you can sign your document. This is issued by Government of India.
Yeah. So,
And you'll have to see, you take photograph of your signature and putting it is not digital signature. It's actually your digital signature, and it is unique to the document that you're signing, so that the signature and document is bound together.
You also have apps like DocuSign, which will allow you to sign digitally.
Yeah, that was my next question, because very often, we are also interacting with a very young population, some of them in the BPO, some of them in the retails who are, just about 20, 21. They've not got down to having something called a digital signature. They're not even yet probably in the tax bracket to have even got themselves a digital signature for IT purposes, etc. So then a DocuSign works. That's where I wanted to make this clarification, because a lot of us don't have a digital signature. I mean, in this country, I don't think half of us would, our employees would not necessarily have a digital signature.
At least I think IC members, you should start having one, external, internal, all of us, because we are giving autographs by the day.
For us, true. For us, different, but all our respondents, our agreed witnesses, they're from very different strata in society also. Sometimes when you're with the blue-collared workers, they don't really have even access to the software from which they can insert a digital signature into the document you send them. They might have an email, but not the software to insert it. So how do you help them?
So Tasneem, for them, I think physical signature is the only way out. And I'm sure there'll be a factory manager whom you'll have to involve, because there will be a lot of communication that you will need to do with them if you're doing it online. There has to be a representative sitting with them, explaining to them even how to use the technology to speak. Right. So I think you should take their help and get a physical, sometimes thumb impression. That kind of level of, sign off is required. So
Sorry, Smita. And for someone who's like what you mentioned, a blue-collared worker, one of the other suggestions is that the entire proceeding of recording his or her statement be done in person. So the IC themselves, because the quorum is only 3 in IC, the IC themselves go, and of course, I'm not talking about COVID times, but I'm just saying that in regular times, we suggest that for people who are unable to use technology effectively, we suggest that please go finish the entire thing, at least for that particular person, in person, in the physical space.
Okay, great.
Okay, guys, I being the moderator, I've been a terrible moderator because it's 20 minutes over time. But I know it was an interesting conversation, and that's why I didn't want to put a break to it. A lot of learnings from the two of you and a lot of sharing from the group here. I am leaving this richer. I am looking forward for more such conversation. Thank you for joining us today.
Thank you so much, Smita, and the entire team of KelpHR for this opportunity. And for ILA, Madhura, thank you so much.
Thanks everyone, and thanks Jana. It was very
Thank you,
insightful.
sir. We'll connect. I'll connect with you offline. Thank you.
Okay,
See you.
take care.
See you, everyone. Bye-bye.
Thank you. Bye-bye.